Good morning to all. I welcome you all to today's webinar on search, seizure, investigation and survey actions arising under the law dealing with income tax law as well as GST law and economic offense. Today we have two sessions, one on legal consequences, implication arising on resulting on investigation, search, survey under the Benami law, PMLA, Black Money Act, Income Tax Law, and the legal remedies available to deal with the same by the eminent faculty, Advocate CA Ashwini Taneja ji. Sir, I welcome you and I thank you for accepting our invitation. Advocate Amit Khemka ji, Supreme Court lawyer. Sir, I welcome you and thank you for accepting our invitation. And the second session, we have Advocate Sailesh Seth, who will deal with search and seizure under the GST law. Today, we are going to learn many things which is relating to search and survey investigation and the investigation, search and other laws which are related to them when we are entering into the search and when we are giving some statement, and what are the implications in under the other laws like Benami law, money laundering law and Black Money Act. This today we will deal with, the eminent faculty will explain us in the given situation, how to tackle the situation, how to deal with it, and how to come out of it. Actually, the issues which are going to be addressed is about the recording of statement on oath and retraction of the same, if the same was recorded involuntarily, incorrectly, or illegally. Evidentiary values of retraction statement under different situations. Implication of statement recorded under the particular proceedings carried out under the specific law upon the proceedings carried out under other laws, and many things. With this, I once again welcome you all, and I now request Ketan Bhai to address to us. Ketan Bhai, over to you.
Good morning, everyone. Respected speakers, Shri Ashwini Taneja, Shri Amit Khemka ji, Sailesh Bhai Seth, who will be joining, of course, in the due course of time. Committee chairman of both the committees, Dinesh Bhai, Atul Bhai, Ashok Bhai, the co-chairman of Directors Committee, Viraj, Radha, Mr. Shivan, who is going to assist us in this entire discussion by way of putting up appropriate question to the learned faculty and dear participants. It's a great pleasure to be with having this session in the morning in the Saturday morning, and it's a pleasure to welcome all of you to this very informative session which we are going to have. As Dinesh Bhai mentioned, that the search and seizure action, what are the areas where the committee is looking forward for this discussion. This timing of this session, this program has been very absolutely appropriate, because last month and last quarter of any financial year is always a challenge for the government to increase the revenue, and therefore many searches, many surveys do happen in this period. We always have been facing this issue as to what kind of a statement will be an appropriate statement, what are the evidential value of that statement, and therefore in the stressful atmosphere of a search, at times people end up giving the statement, people end up accepting some of the additions which are otherwise not even there. The way in which the department handles with a high-handedness approach, we have all been witnessing that, and therefore at times it so happens that though my income is not there, I end up making those declarations, and then I face the consequences later on, including tax, interest, penalty, and even prosecution at times. So those difficulties which come up, therefore absolutely timely session by this committee. So we are all looking forward to. Coming to the chamber's activities, friends, I think some of you may be non-members, so let me just summarily mention few activities of the chamber. The chamber is a very vibrant organization, a very energetic organization of 96 years old, and we are marching towards our 100th centenary year very soon. We are the oldest professional organization of tax professionals in the country. Around 4,000 members are there all across the country, which also spans across the profession. So we have chartered accountants, we have advocates, company secretaries, all and the tax professionals also. So all of them are our welcome to be our member. the activities of the chamber revolve around the motto that the education is the prime thing, and therefore, all our educational programs are always focusing to cater to the need of the tax professionals, also accounting and auditing, etc., which has been the recent movement in the chamber's activities. All across our journals, of course, are the mouthpiece of the chamber, and the articles in the journals are something which one always will crave for, the special stories which we come out with. So every issue, if you pick up, you will have a special story. Like the February issue was, of course, on the finance bill. And if you pick up a particular issue, you will see entire thing on the particular subject. So that is something where the professionals will always find it very handy if they are dealing with any particular subject. The conferences, seminars keep on happening every round the year, and I think many of you must be receiving the emails from the chamber. Of course, the RRCs are the greatest thing which chamber always does. 3 RRCs in a year, and we are going to start our our most awaited our RRC on this week only, coming week on Thursday, 10th onwards. Various activities keep on happening, and therefore, I would not spend much time on activities. I would request all of you to visit the Chamber's website, www.ctconline.org, and see whatever events attract you. You may please join. I also request, if some of you are non-members, please consider joining as a member of the chamber, so as to cater you in a very, very efficient manner. With that small background, I think we are all eager to listen to the learned faculty, and I am told that today we are going to have it in the form of a question answer session. So Mr. Shivan will then put up the questions, and then the learned faculty would take the responsibility of answering those, Mr. Ashwini as well as Mr. Amit Khemka. So with that, I think we are all heading towards a very, very informative session. And of course, in the second half of the session, Mr. Sheth will also deal with a lot many intricate issues on the GST front. So with that, I think I'll hand over back to Dinesh Bhai to introduce the learned faculty and take the proceedings further. Thank you.
Thank you, Ketan Bhai. Now I request our co-chairman Ashok Mehta to introduce the speakers.
Yes, the pleasant task of introducing Mr. Amit Khemka and Mr. Ashwin Taneja, sir. Amit Khemka ji is a litigation lawyer with experience of almost 37 years at the bar. He has handled large number of cases involving complex issues in the domains of civil, criminal, and constitutional laws. When the district of Gautam Buddha Nagar was abolished, he was the lawyer who fought in the High Court and the Supreme Court to get the district status to restored to Gautam Buddha Nagar. Cases handled by him have made significant impact legally and socially. He has a large client list, including corporates, professionals, public servants, and politicians. For his legal acumen, he is regularly invited to All India Radio and various TV channels, and has participated in about 400 debates on All India Radio and about 1,000 debates on TV on diverse legal subjects. He has addressed the Standing Committee of Parliament and regularly delivered lectures at different forums, including chartered accountants, lawyers, and students. He has held various posts in a number of NGOs, lawyers associations. He has been bestowed with various awards and recognitions by a number of organizations for his legal acumen and services to the masses. His CV goes into 4 pages, so I'll not introduce. Everyone knows him. He's been a regular speaker and has presented papers at various associations of the Institute and the CTC and BCA. I welcome you, sir. The pleasant task of now introducing Sir Ashwin Taneja, sir. Sir is a master's in LLM. He is a academician. He has done his Indian Council of Arbitration from Nehru. He's a member of Indian Council of Arbitration, New Delhi. He's a member of the Institute of Chartered Accountant of India. He's done his company secretarial. He's also done his ICWA. From 1995 to 2007, he's practiced as a chartered accountant in various areas of auditing, due diligence, tax planning, and litigation. From 2007 to 2015, he's practiced as a lawyer with the firm RRA Tax India, New Delhi, and appearing before ITAT, High Court, and Supreme Court. In 2015, he was elevated to the member of Income Tax Appellate Tribunal and was posted in Mumbai bench, where he delivered more than 2,000 judgments covering wide variety of issues. Then in 2017, he resigned as a member of the tribunal and joined back in his old charm and passion of legal profession. Currently practicing again as a lawyer with RRA Legal Delhi, specializing in the area of anti-money laundering, Benami law, Black Money Act, SFIO, and income tax, and making representations before adjudicating authority and appellate tribunal of Benami law, PMLA, ITAT, High Courts, and Honorable Supreme Courts. He has presented various papers at various forums, and He is a profile speaker and has delivered presentations and lectures on PMLA, Benami, and income tax law. He has given interviews and published articles, papers, and complex issues arising from the subject on the above subjects on various TV channels and newspapers. A good number of landmark cases argued by him before different courts or authored by him at the tribunal have been published in leading tax journals of the country. He is always available for discussion issues arising from these subjects. We welcome you, sir. We couldn't have more and better faculty on the issue besides you both. And I welcome also the person who's going to request the put the questions, Mr. Sivan Kukreja, sir. I welcome you, sir. Over to you. The participants are eager to hear you all out. Thank you, sir.
Over to you, Ashwini ji. Over to you.
Thank you very much. First of all, Mehta Sahab for the kind words, and Dinesh Bhai for inviting us. You have been taking a lot of care in seeing that the topics are properly drafted, the entire curriculum is properly drafted. And thank you, Ketan ji. Always being an inspiration for all of us, like always. And thank you all other organizers. I can see many people are there contributing. Atul Mehta ji is there, Viraj is there, Radha ji is there. So thank you all the organizers and dear participants on this pleasant morning of Saturday. You have spared your valuable time to make the discussion and enriching discussion today, which we are going to have, and especially in the presence of my esteemed learned colleague Amit Khemka ji, whom I consider as my guru also because of his able guidance which he gives in these areas in which we chartered accountants and tax lawyers have always found ourselves deficient, because these new laws have come up which have been introduced by the government to clean the economy, to streamline the economy, but there is lack of clarity in criminal jurisprudence, in civil, in everywhere, that how, in what manner these laws should be properly and fairly implemented. And doctrine of proportionality should also be maintained. This is the biggest challenge which on both the sides people are facing. I mean, on the administration side, on the judiciary side, as well as on the sides of the citizens. I mean, this challenge is coming up, that how the doctrine of proportionality can be, observed, because what is happening is, even for the small mistake, which may have been done knowingly or even unknowingly, the consequences are very, very harsh, which, begin from attachment of the properties and go up to prosecution, arrest, fine, what not. So, I mean, how to ensure from our side that we are able to guide our clients, that in what manner we can assist in an appropriate manner, that investigation should be done by the agencies, what can be our active role so that fairness is maintained, the objective on both the sides are achieved. And then whenever search takes place, the search action should also happen in this manner, that all legal compliances take place on both the sides and nothing untoward or unwanted happens, nothing excess happens, nothing short happens. So this is a tough challenge which is coming up, day in, day out. So we have drafted some of the questions in such a manner that various issues, fundamental issues which are coming in the minds of everybody are addressed, not only from the point of view of the technical provisions which exist on the different laws like PMLA, Benami or Black Money Act, or whatever the fourth law is there today. So apart from that, how we can wrap around the finer judicious principles which are enshrined in our constitution, and also in the umbrella legislation such as CRPC, CPC, and Indian Evidence Act. So the problem which we are facing, because these laws are being implemented, whether you name it Benami, PMLA, Income Tax Act, or FEMA, whatever laws out of these 4 or 5 laws dealing with economic offenses, the problem we are facing is mainly because of the reason that these laws are being implemented dehors these umbrella legislations, meaning thereby, when you do not consider the principles of natural justice into account, when you do not take into account the finer principles laid out under Indian Evidence Act, when you ignore the basic practices, the fundamental practices as have been set out in CRPC or CPC, the result will be always disproportionate and unwanted and unfair or harsh, etc., etc., etc. So how with these things are also to be kept in mind, or how we can play our role in reminding these respective agencies that these provisions you cannot forget. What I am trying to say is, now all these legislations, they are offsprings of our constitution only. So they are siblings. Since they are siblings, bringing out one legislation does not mean that the effect of the other legislation is erased. So suppose PBPT Act has been introduced, that does not mean the Companies Act will lose its value. Unless, of course, specifically a provision is brought out to erase or override a particular provision of other legislation. Otherwise, all the legislations have to coexist. If Income Tax Act is there, if then PBPT Act is there, then both have to coexist. So harmonious interpretation has to be done. This is not only I am saying, this is what has been opined by the board, Central Board of Direct Taxes in its instructions. Similarly, when you bring out these laws, we have to also not forget that Companies Act exists, which allows structuring in a legal manner. Then above all, then all these legislations, all these economic offenses have to take care of the fundamental principles based upon which our constitution is based, and which have been infused directly into these laws, umbrella laws such as CPC, CRPC, and Indian Evidence Act, and few other things. So there we will have the greater benefit today of the presence of stalwart like Amit Khemka ji, that how we can wrap around and ensure that these principles are not forgotten. So we have taken a good care in drafting the question in such a manner that we can have the a tinge of and flavor of the understanding of these laws also side by side. But whatever is left out at the end of the session, I hope the esteemed organizers will connect you with us through your questions so that we can take care of that, whatever is deficient or something like that. So I think Khemka ji, if you want to say anything to begin with, otherwise Shivan can begin with his questions, or you can set the ball rolling, Khemka sir.
My only comments were that Ketan bhai said that we would learn today. So Ketan bhai, we are not here to teach you at all. We are all here just to discuss, because these laws have created such situation because of the vagueness in the drafting probably of the laws, that multiple questions are arising. After 20 years of the act coming in, Supreme Court today is seized of more than 50 legal questions on PMLA itself. And the Supreme Court is hearing those questions for last almost 3 months. And I am very sure that even after the decision in this case, the things will not settle down. Things like retrospectivity. Why couldn't the legislature say that whether they want to make an act retrospective or prospective? They could specify it, but none of these laws, they have specified whether it is prospective or retrospective. And in all these laws, whether it is Black Money Act, whether it is Benami, whether it is PMLA, this question of retrospectivity and prospectivity is plaguing the whole spectrum of judicial pronouncements. So because of the vagueness in these laws or drafting of these laws, these kind of legal questions have cropped up, which we professionals are forced to deliberate upon. We have to, for the greater clarity, in the interest of our clients, in the interest of the profession, in the interest of the legal enforcement, it is necessary that we deliberate. And I really thank organizations like CTC who so enthusiastically arrange such discussions. And it is certainly an honor to be a part of all of you, the learned and enlightened people. So excuse us for any mistake which we commit. Don't ignore it, but excuse us. Please point out if we are committing any mistakes. You all are welcome to participate in the discussion. Any questions coming in, those are also very, very welcome, because we all are just thrashing out the legal situation. We are not here to give any lecture to you. The purpose of making it interactive is that only, that we all discuss. Any one of you who wants to intervene in between, I will request you to please intervene, because we have such learned people. Like I can see so many of my learned brothers and sister. So please go ahead and please intervene during our questions or during our deliberations. We will welcome that. Thank you so much. Thank you once again for inviting us, and we will try to do our best, sir. Over to you, Shivan.
Thank you so much, sir, for inviting me and giving me this opportunity. My first question is, what are the provisions regarding search and seizure under these laws?
Yes. So let us focus upon these 4 laws to begin with. That is, first of all, Income Tax Act, Benami, PMLA, and Black Money Act. Now, as far as search provisions are concerned, there are direct provisions with regard to search under Income Tax Act, as we are all aware of, beginning with section 132 onwards, and under PMLA, which are contained in under section 17. There are no direct provisions with regard to search under PBPT Act or under Black Money Act. But the enforcement task of both these pieces of legislations are with Income Tax Department only. So practically speaking, I have seen that the platform of Income Tax Department is used for carrying out search if there is any need arises under any of these laws. So, I mean, the Benami Prohibition Unit and the Assessment Wing of Black Money Act, they are working in tandem with the investigation wing of the Income Tax Department. Rather, they are part and parcel of the investigation wing itself. The BPU itself has been carved out of the investigation wing of the Income Tax Department. So searches are carried out in which the officers from these 2 domains are also part of the search team. And then the material is gathered during the course of search. Or even if they are not part of that, then the reference material is supplied to them immediately, whatever is gathered during the course of search. I think you must have witnessed it now in last 1 year, things happening like that. So direct provisions under these 2 legislations, and indirectly it is there in all the 4 legislation. Yes, the provisions with regard to section 132 under Income Tax Act and section 17 are at little variance with each other. The provisions are quite exhaustive under income tax law. The rules and regulations are quite exhaustive. But under PMLA, the provisions are not that elaborate. The rules are not that elaborate. So, I mean, there is a lot of scope of leeway and trial and error kind of thing. But whatever it is, it is. And we will discuss in course of our discussion also what is the difference in the provisions which leads to the difference in powers of making seizure or impounding, etc. That we'll discuss in course of the discussion today. Thank you. If
Thank you
Khimka
so much.
wants to add anything on this, otherwise you can go ahead.
Sorry. So as Ashwini sir has very aptly said that there is a lot of piggybacking in by authorities under whether it is under Black Money Act or under PBPT Act, or so they are using the provisions of search and seizures in other laws actually, and we will discuss as to how and it is being done and what is the evidentiary, or what are the hiccups which ultimately the departments might face ultimately. So that we will discuss during the course of our discussion. So as of now.
Yes, Shivan.
Sir, sir, my next question is, what is the need and rationale for giving powers to do search under these laws?
See, Shivan, it is absolutely clear that any of these people who are alleged to be involved in commission of offenses or commission of wrongs under these economic laws, such as Prevention of Money Laundering Act or Income Tax Act or the Black Money Act, they are not going to come forward and straight away give evidence of their uh, being involved in the wrong to the department. All these offenses, as we know, are committed in the secrecy. They are results of conspiracy, which is hatched behind closed doors, which is hatched under some kind of a cover. So it is necessary that those covers have to be uncovered. And because of that, such drastic provisions are legislated under all criminal laws, which allow the agencies to invade the privacy of the person concerned. Searching somebody's residence or searching somebody's business is a direct invasion on the privacy of that person. And therefore, it is only under the peculiar circumstances where the high ranking officers of that department think, or they have material enough to come to a conclusion that it is a case where the privacy of an individual should be invaded in order to uncover the wrong which has been committed under closed doors, under the cover, or the conspiracies have been hatched. So it is obvious, and it is for anybody to see that these provisions are intended only for the purpose to be utilized against those persons against whom there is a strong suspicion, or there is enough material to suspect that they are involved in some kind of an offense, and they are not readily coming out, or they are not likely to readily come forward and provide the evidence or share the evidence or cooperate with the investigation. So under these circumstances, it becomes necessary that the power of search and seizure is bestowed upon these departments or these agencies who are investigating the whole thing. However, it comes out from the reading of these laws itself that it has to be very it has to be very carefully carefully exercise these kind of powers. As Ashwini ji often says, that they have to be utilized as surgeon's knife, only for the purpose of, it should not be a butcher's knife, it should be a surgeon's knife. If the duty is cast upon these agencies to use these powers of invasion of privacy, like invasion of a body, in fact, in terms of the medical science. So they are supposed to use it as a surgeon's knife only to take out the tumor, not to butcher the whole thing, not to kill a person. So that is the whole thing. That is what the law has intended. That is what the courts have been saying. That is another thing, that unfortunately in many cases, the powers are used as butcher's knife, and that results in grave injustice. And that is how the role of professionals comes into that, how it can be curbed, what remedies are available, and all those which you will certainly ask questions about and which we will discuss about. Ashwini ji.
Yes, actually very nicely summed up. A few things I would like to make a mention specifically. So the need, Shivan, you asking is a very good question. In fact, in simple words, it can be something like that, something which these investigation agencies or enforcement agencies cannot achieve by making a routine investigation and inquiry, something which is of a hidden nature, which is not going to surface unless more invasive actions are done. The search is required to be done. That is what the provisions say. And to be more precise, I will deal with two sections, section 132 of Income Tax Act and section 17 of PMLA. You know, the uniqueness of today's session, which is going to be there with the good wishes and efforts of our esteemed organizers, is that we will have a comparative analysis of an understanding of all these laws put together, how the things are there in different laws. So as I said, direct provisions are not there under Black Money Act and BBBT. So I have picked up Income Tax Act and PMLA for the timing as far as this issue is concerned. So 132 of Income Tax Act deals with search or under Income Tax Act, and 17 under PMLA, that is search by the Enforcement Directorate. So 3 circumstances have been mentioned under section 132, wherein the need will arise to do search. That, and for that purpose, a satisfaction has to be recorded. To this extent that these 3 clauses are applicable. 132 subsection 1, clause A, B, and C. Clause A says when there is a failure on producing the books of accounts or person on the issuance summon to a person. Second, if summons is to be issued, there is likely to be failure. Third, the person is in possession of any money, bullion, jewelry, or other valuable article or thing, and such items or things, either wholly or partly, are income or property which has not been or would not be disclosed. Suppose a person is having huge cash, say of amounting to rupees 100 crores, say election rallies, it happens. So it is not likely to be, I mean, it is somebody's income, it is not likely to be disclosed as income. So somebody is having huge amount of cash in his house, huge amount of gold, bullion, or jewelry at his house, or certain other valuable things. It could be anything. So if they are there which has not been disclosed or not likely to be disclosed, so there should be these 3 reasons when the need arises to do search. Now, if we read section 17, which grants power to do search to the Enforcement Directorate, where the DI, director means director of ED, Enforcement Directorate, or any other officer not below the rank of deputy director authorized by him for the purpose of this section, on the basis of information in his possession, has reason to believe. So he should have reason to believe for what? And that has to be recorded in writing. A, the person has committed any act which constitutes money laundering, or is in possession of any proceeds of crime involved in money laundering, or is in possession of records relating to money laundering, or is in possession of any property related to there. So if a person is having proceeds of crime, or records related to proceeds of crime, or property related to proceeds of crime, or even if he does not possess anything, but he has committed the offense of money laundering. So in either of these 4 conditions, the reasons to record, reasons to carry out search may be recorded, and accordingly search may be carried out. But friends, you know, the irony is what here, which I was talking about, that which leads to the breach of doctrine of proportionality. Now the need is specific. The law does not generalize its power of search, not at all. It is very specific, very confined, very clear that these are the circumstances, 3 circumstances Income Tax Act, 4 circumstances under PMLA. But the irony is there is no mechanism to check whether these circumstances existed before the search was authorized. I mean, at the time of search, we will deal with these things. Hardly warrant is shown. Satisfaction is never shown. Okay, I can understand that at the time of search, no need to show it because you want to maintain privacy and confidentiality of the action. Even subsequent to the search, there is no system of reproducing any satisfaction. Not only that, even if the, I mean, you have to toil hard for requesting the court to call for the satisfaction. Number 1. Number 2, there will be hardly any cases where you will find that the search has been quashed on the ground that the satisfaction was not proper. So that means either there is a lack of will on the part of judiciary to quash searches for want of proper satisfaction or reasoning, or there is some liberal attitude which is being followed in this regard. So that gives rise to sometimes harsher actions even where these are not required. I am not at all going to suggest during the course of my deliberation that wrongdoers should not be punished. What I am going to be careful about, or what I want to give the precautions about, is that how to ensure that only wrongdoers are punished, not the persons who are innocent. So since innocents are also being crushed if the law is not properly complied with, I think some need to relook at the approach in which we are working arises here. Thank you, Shivan. You can take the next question.
Thank you so much, sir. So my next question is, what are the provisions with regard to investigation by various agencies under these laws?
Yes, I will begin and then I hope Khimka sir will elaborate it better. So with regard to investigation, we mean when other than search, a agency requires to make some inquiries. So many provisions are there in the Income Tax Act, and direct provisions are there under PMLA, PBPT, and Black Money Act. So Income Tax Act contains, various provisions for making investigations, such as these such provisions are there. Then of course, section survey provisions are there. 133 is there for making inquiry. 133A is there. Then various other powers have been given to call for information from various agencies. Apart from that, assessment proceedings are there. Post-search assessment or regular assessment, such as 143.3, then post-search 153A, etc. So, I mean, the provisions of assessment and investigations are there. Under Black Money Act, Section 10 gives the power to make assessment, but to carry out inquiries, Section 8 is there, which empowers the officers to issue notice and to make inquiries, etc. Under Benami law, Section 19 to Section 23 are the provisions which gives powers to make inquiry before launching the main proceedings. Then main proceedings are launched under Section 24 if a officer has reason to believe that so and so property is Benami. Under PMLA, we are all versed with that most draconian power any law could have is under Section 50, whereby they carry out the investigation. Apart from provisions of this search under Section 17, 18, 19, and then we have Section 50, which gives power to the enforcement director to record statement of the people. Now, the next incidental question, which I would like Khimka sir to comment upon. I mean, these investigations provisions, wherever these are there, I mean, they have also have some provisions that so and so provisions of CPC would be applicable, or so and so provisions would not be applicable. I mean, so to what extent provisions of CPC in general, if you can throw some light, would be applicable here? I mean, what does it mean when they say so and so provisions will not be applicable and so provisions will be applicable, etc. So Khimka sir, if you want to add something on this.
We have the benefit of Mr. Shailesh Seth, advocate, with us. I could see him. Namaskar, sir. Namaskar. It is a pleasure to have you, sir, amongst us. And I said earlier also to all the organizers and all the esteemed panelists that whenever there is a requirement, kindly intervene. So I will I'll invite you that wherever we are going wrong, please intervene and correct us, sir. So you are there, so please interject and please correct us, sir. It's a pleasure to have you, sir.
No,
Welcome, Shailesh.
I'll just good morning to all of you. I will not take your time. It will not be fair on my part to intervene, particularly when PMLA and IT is not my subject. I just wanted to test also whether there is no technical glitches. Ketan knows very well. I belong to the Stone Age as far as the technology is concerned. So didn't want to take a chance. Please carry on. I'm also just in the midst of preparing my session for my session.
Please, sir. Thank you, sir.
Thank you for your kind words, sir. Thank you very much.
Thank you, Shailesh. Thank you for joining us.
Thank you.
So what Ashwini sir said that technically what I understand is that what has been happening that whenever these laws are made, an impression has been created as if the whole fault lies with CPC, or the whole fault for whatever are the ills in the judiciary.
Sir, may I intervene for a second, sir? Khimka sir.
Yes.
In fact, what I was going to ask, apart from whatever you are going to answer now, is also that which you kindly cover, that most of the provisions contain provisions like this. For example, Section 19 of PBPT, Benami Act says, power of authorities. It says, the authorities shall, for the purpose of this act, have the same powers as are vested in a civil court under Code of Civil Procedure while trying a suit in respect of following matters, namely discovery of inspection, enforcing the attendance of any person, then compelling the production of books of accounts, issuing commissions, receiving evidence on affidavits, and any other matter which may be prescribed. So everywhere in all laws, these 3-4 sections, this kind of provision has been added to. So what does this mean also, if you could also cover in your deliberation?
See,
Please carry on.
all these powers are available to the court. What has been, I was just going on the background of it.
Yes, please go ahead. Sorry for
what is necessary to appreciate. See, there is always an allegation that there are delays in the court, in the judicial system. The things are not, done properly. The systems don't work properly. And the blame for that has always been put on the procedure or on the lengthy evidences. And for that purpose, whenever these new age laws were made or are made, what they do is that they say that the strict principles of evidence will, the provisions of Evidence Act will not apply. Similarly, the provisions of CRPC will not apply. And these provisions are applied only to a limited extent. Another problem which has arisen is that because the statements recorded by the police are not admissible in evidence, an effort was made in these economic laws or in the laws related with the terrorism or in the laws related with the control of narcotics trade. An attempt has been made to say or to make the investigation more effective, that the investigation itself will be a judicial proceeding. And in that process, only to the limited extent, they have said that the limited powers of the court, such as summoning, such as appointing commissioner, such as collection of evidence, such as summoning of evidence, documents, etc. These kind of powers will vest in the officers while doing investigations also. In my humble opinion, all these powers already existed with the police in CRPC also. However, because those evidences collected or those statements recorded by the police were not directly admissible in evidence, except by following due process and due procedure of law, an effort has been made in these laws to make the evidences directly admissible in law by calling them judicial proceedings or by classifying them as judicial proceedings. And therefore, these kind of provisions have been made that only a limited power under the CPC will be there, or limited provisions of CRPC will be applicable. So that is the only reason that these kind of provisions have been made. And I do not think still that the basic principles of evidence or basic principles of constitution can be given away, and those will continue to guide the investigation as well as the prosecution of these cases. Any other thing which you want to ask, Ashwini-ji? Then
no, I think for the timing,
yes.
broad analysis are there, so we can go to the next question, and then during the course of discussion we will take it up further.
Yes.
So my next question is, what are the provisions with regard to arrest or detention or custodial interrogation under these laws?
Shivan, there are no provisions about arrest or detention so far as Black Money Act or PVPT Act or Income Tax Act are concerned. The only provisions about arrest are in the PMLA. It is there, and it is only under this particular act out of these economic laws that the power of arrest or the power of custodial interrogation is there. Rest, none of the acts provide for any kind of custodial interrogation. However, the power to record a statement or power to summon documents or power to summon information or gather information is existence is there in all these laws, where the officers concerned during the investigation can investigate by summoning a person and administering him oath, and those statements are considered as statements given during the course of judicial proceeding. We will deliberate on what is that judicial proceeding and what is the meaning of that judicial proceeding. However, these are basically the provisions of other provisions apart from search and seizure, other provisions regarding the investigation. Ashwini ji.
Yes, in fact, I was wondering one thing, that all the laws are economic laws. Now, when even Black Money Act, under Income Tax Act, which has also huge implications, the need was not felt, or even under PBPT Act, which the government is taking very seriously, power of arrest has not been given. What need was felt, or what must have been there, the reasons to enshrine a particular provision, section 19 of PMLA, granting powers of arrest. Now, one of the reasons could be that it is dealing with heinous offenses also. For example, drug trafficking, smuggling, weapons, etc., etc. But they are all scheduled offenses, and for which separate mechanism is also already there. I mean, they are punishable under IPC, and power of arrest, etc., is already there. And they have also now made certain offenses which are not as heinous as they were, like I mean, pollution control laws or some other things. So, and already arrests, etc., will take place over there. Here, the agency is required to see the aspect of flow of money only, like other three legislations will be looking into. So what must have been the reason to grant power of arrest to the Enforcement Directorate? Because power of arrest is already there with the other agencies if required. For example, suppose it is a case of bribery, prevention of corruption. So CBI has power of arrest. You take any offense, power of arrest is there with the main investigation agencies. So what was the need? I mean, I'm not able to imagine for giving them this additional power of arrest. When the main investigation agency has the power, they are making investigation. So this agency can make use of that investigation. Is it because of some international pressure? I mean, because this PMLA law has been brought out here to, I mean, in consonance with the need arising from the pressure being made by the United Nations way back in 1998 when the resolution was passed at United Nations Security Council. So, I mean, it is in consonance of that this law has been made so draconian, so harsh, so strict, or anything else comes to your mind? Khimka sir. Because
I feel that what probably was troubling the lawmakers was that a commission of offense may not be viewed that seriously as the utilization of the proceeds of that offense. If a person who has committed an offense is allowed a dominant position in the society or in the social fabric because of his criminally earned wealth, that can create a havoc with the society, and that has been creating a havoc with the society.
yes.
So probably that is the reason the offense of money laundering is viewed even more seriously than the offense of than the predicate offense or than the scheduled offense itself. So that is probably the reason that anybody who earns money by criminal means, he should not be able to use the fruits of it. He should not be allowed to come in a dominant position in his life because of that wealth. So that is probably, but nonetheless, Ashwini ji, I am in profession for last 37 years plus 3 years of my legal study, 40 years now. I have seen phases of seriousness in the judicial system. There was a time when for 498A offense, the husband and the father, parents, and even the distant relatives never used to get bail. So that was a time, that was an aura where matrimonial offenses were taken as very, very serious offenses. So probably we are going through an era where money laundering is the most serious offense on earth. And I'm very sure that 10 years from today, there will be something else rather than money laundering. There was in 80s, Customs Act used to be, if a person was found with 10 grams of gold on an airport, he was put behind bars. If he was found with few watches, 2 or 3 watches, coming up with 2 watches or 2 bottles of liquor, he would be sent behind bars. So those were the times when Customs Act was considered very serious or very heinous by the courts of law, by the society. So I am very sure that this is also one of the phases, because objectivity is lost when you start taking decisions on the basis of impressions. It should not be. After all, the punishment provided in Section 4 is only 7 years. So the heinousness of the offense should be directly proportionate or should be directly viewed on the basis of the punishment provided by the law. If this offense was very more serious than, as some of the people try to suggest that this offense is more serious than even murder. Now, then you should provide hanging for it, or you should provide the life imprisonment if it is that serious. But the law makers in their own wisdom have not done that. So the heinousness or the seriousness of an offense should directly be decided by what is the punishment prescribed. On the other hand, Supreme Court says in Arnesh Kumar that offenses up to 7 years of imprisonment, you must grant bail as a matter of right. You should not arrest a person unless there are exceptional circumstances for his arrest. While when it comes to PMLA, the law takes a U-turn. So that is a very, we have got into a habit of deciding things on the basis of certain impressions or certain pre-decided, pre-biases, in fact, if I may use the word. So that is unfortunate. It is no doubt a serious offense. We must view it as a serious offense. But that doesn't mean that it should, the objectivity be lost in that process. Thank you.
Yes, Shivan, please.
Thank you so much, sir. So my next question is, what are the rights available with the SSC before the commencement of search?
So, let us talk about search in any case, whether it is search upon an income tax SSC or suppose search by the PMLA department. In fact, theoretically speaking, today we can list out n number of rights, but practically what happens is a different thing altogether, whether those rights, it is possible to, take care of those rights or not. But still, we will list out what are the possible rights that can be exercised. The first right, I think, is that the person has right to see copy of warrant. Now, various unfortunate things have happened that some people under the disguise of a search team from a particular agency have also made attacks, looted the people. So I think the investigation agencies should be keen themselves to show warrants. But in the that Hafiz in the rush, in the zeal, or in the stress of the carrying out search in a very, very fast, expedient manner, they themselves do not sometimes properly show the search warrant, and that is how the untoward incidents takes place. Next incidental question which might arise here is whether a person is required to be served a copy of the search warrant. So for the position of law which has emerged, whether you take into account the judgments coming up or the provisions of law, there is no provision of law which requires service of copy of warrant. And I do not know, Seth Saab or Khemka Saab can throw light on this. I have not found any logic behind it, because I'm not asking for service of copy of satisfaction note. I am simply asking for copy of service of warrant. What is the problem in service of warrant to the person whose search you are doing? What to say of, suppose a person is going to be arrested, he is arrested, he is not even served with the grounds of arrest. And today we are discussing upon that, whether grounds of arrest are required to be given to him or not. You are taking custody, personal liberty of a person, and you are not even giving grounds of arrest. So forget about ground to arrest. I mean, such copy of warrant itself has become a big deal. So that is what I was saying in the beginning. These legislations will be able to achieve its objective without denting beyond a point, or without creating harsher consequences which were not required, without causing the breach of proportionality, only when the fairness is maintained. Sound judicious principle of fairness is observed at every given point of time. So I do not know why it is so. Next, the right is that he can also carry out personal search of the search team. To what extent the search is practically done, to what extent it is not. I have seen in some cases when the search was happening, and the search was there on the diamond company, some of the officials were carrying the backpacks also with them. And during the course of search, the backpacks were allowed by the other senior officers to their junior officers, and they were, while carrying the search, they were having them. Now, this kind of search should be held illegal, particularly when the person can show because sometimes in the companies, the CCTV footage is available. So anything, any bag, any such possession, any such thing which search officers are carrying, that must either not be allowed inside, or that must be frisked properly, because it may give rise to, I mean, any of the unfair things. So I think Khemka sir will remember that case where when we saw the CCTV footage, we saw that persons are doing the such like that. Then next thing which I consider very, very important is that the personal liberties of the person cannot be taken away. For example, I mean, need to have water, need to have food, need to have medicines, need to make urgent telephonic calls in the presence of the officers themselves. There may be some urgency going on, something on the speaker phone, they can talk. I mean, these are the rights which are fairly available, which should be exercised fairly and which should be allowed. Khemka sir would also had something to add on to it. You're on mute, probably.
To my mind, even the presence of a legal practitioner, maybe to a limited extent, it should be allowed, because after all, a person who is searched would never have the courage to ask an officer that I want to frisk you, because he is too afraid to do that. It is only a legal professional or a chartered accountant or a lawyer who can have the guts to say that, sir, please show me your identity. Please show me, please allow me to frisk you. Please draw the documents in a proper manner. Show me the warrant. So all these things, show me your identity proofs. So all these things can be done. And otherwise also, a person doesn't know the law. He doesn't know what can be taken, what cannot be taken. So the chances of misuse of the powers increase. Of course, you should not allow that professional to roam around freely or whatever. But if the person searched needs legal opinion, needs legal advice, that should be available to him. Unfortunately, that law has not developed in our country like this. It is that way in almost every democratic country. If you take example of US A person can refuse to open his mouth without the presence of his lawyer. So he'll just not even talk. And if we call ourselves democratic, that has to be the way. There are scientific ways available of extraction of evidence, extraction of truth. There are very, very scientific methods available and which should be employed and which can be employed. And in fact, those are much more effective and which have much better evidentiary values in the eyes of law than these kind of coercive or intimidating tactics. Thank you.
So I would put it this way. This is a very, very issue which you have touched upon, Khemka sir. I would say something like this, that if the process is to be adopted fairly, then what could be the stumbling block or obstacle in inviting a lawyer at their own? Rather, they should themselves say, do you want to invite any of your consultant who could be a legal lawyer or a chartered accountant? And if he says yes, so he should simply put forth, all right, we will put this condition. He should stay away 5 feet away from you. He would simply witness. He will not obstruct in anything. And if even this kind of privilege is not provided, there could be only one reason. What could be the other reason? That either the entire process is intended to be carried out unfairly, or there is some intention to make use of force which the law does not allow. Otherwise, what could be the reason, if the entire process is to be carried out fairly, to not to invite the consultant? Rather, it will be in the favor of the investigation agency when the legality is challenged out of the action before the higher court. So before the higher court, they can say, sir, he is absolutely telling something incorrect. You can kindly ask, because his lawyer was present. He's saying there was use of force. He's incorrect. His lawyer was there. How could there be use of force when the lawyer was present? Rather, I should be in a position to challenge the legality of the search on this very ground. Sir, there was use of force. This document was not found from my possession. They are absolutely wrong. This Panchnama has been forcibly drawn. They did not even let me invite and call my lawyer or my chartered accountant. So rather, the law should evolve in this area so that the fair practices can be adopted on both the sides. Thank you.
Thank you so much, sir. So my next question is...
There's a comment by Mr. Ashok Sharma. Presence of authorized representative. I appreciate what you say, but court judgments are against department is also saying we are just carrying on operation/search. So presence not necessary. Mr. Sharma, that is exactly our point, that in the search or any of the investigations have to be fair, reliable, just. So if you are not allowing, if you are carrying out that search and its authenticity can later on be challenged, just because you did not allow the person legal advice at that time, it can also become one of the grounds that he was not legally aware. You did something legally incorrect. You planted something. Now, if his lawyer was present, if his chartered accountant was present, can he say that it was planted? He cannot. Rather, it will add to the department's action. I am very sure that a lawyer is, you cannot allow a lawyer or a chartered accountant to fiddle with the evidence. You will say, okay, sir, we are giving you a chair. Please sit respectfully. And if your client needs any advice, you give that client an advice. We have no problems about it. So that will only add fairness and reasonableness to the whole, and which will make it in turn authentic and reliable, and will have much better evidentiary value in the eyes of law. Thank you, Shivan. You can go ahead.
Thank you so much, sir. Sir, my next question is, what precautions the search person should take while the Panchnama is being drawn?
Yes, very good question. Before Khemka sir gives his views, I would like to make a mention about few things based upon my experience, which I have seen. In fact, the process of search and the entire exercise is very, very important for both. If it is important for department, it is important for the person concerned who has been searched, so that the truth is recorded, and it is recorded in the truthful manner, truthful and complete manner, because slight variation here and there can bring out a material change in its legal and factual implications. Now, to begin with, when the Panchnama is being drawn, it should record the proper events. When the search began, how the search was suspended in between, when it resumed, who were the witnesses, who called the witnesses, whether the witnesses were also offered for search, whether the department officials or the search officials were also offered for search. Then, importantly, if there are certain seizure of records, then from where the records were exactly found, in whose possession, if there is any seizure of money, bullion, or jewelry, exactly in whose possession and from where and in what manner it was found. For example, it is a building comprising of few floors wherein different family members reside, different rooms are there. Then if the cash is found, say rupees 1 crore, and it is say it is found, say search is upon Mr. X, so from Mr. X 1 crore is found. It will be very difficult for Mr. X to explain later on, no, it is not my cash. It belongs to my 3 brothers, their wives, their children, my parents. So if it is divided into 10 parts, the situation will be different. And if it is combined at one place, situation will be totally different. Similarly, gold, jewelry, if it is found, where from it is found, in whose possession it is found, some written slips are found, from where from it is found, from my cupboard, from my drawer, or my servant's drawer, or some driver's drawer, or in servant's room, or somewhere in the bedroom of my parents, or I had a guest, some guest room. So, I mean, exactly the things have to be recorded. For example, in one case, Kinka sir will remember this was a case of Hyderabad probably, and the search happened at the premises of one gentleman, and there was many family members were living there. So search registered deeds were found therefrom, and registered deeds were shown to have been found from the room of that gentleman only, upon whom search was intended to be carried out. Whereas some of the deeds were found from the room of his sister, who was a widowed sister who was living there with them, and also with their grandmother who was living with them. So those deeds could have been found in their premises, no problem. But if those deeds were found from his premises, from his room, then the whole allegation which the department was intending to make, that this is Benami property, Shivan is remembering that case also probably. So it is proved on the face of it that what he was doing with the title deeds, whereas his sister could have had possession of that. But if he was possession, the chances of it becoming, because Benami law, it contains a thin line only. Suppose property is purchased in the name of sister, it could be Benami. But if the title deeds are with brother, it would be Benami. But if the title deeds are with sister only, it would not be, because then it belongs to sister only. So slight difference here and there will mark a lot of difference. So events should be recorded truthfully and in the complete manner, as it is manner. Yes, Khemka sir. There would be many things to be added to it actually.
Yeah. See, to my mind, first and the foremost care which must be taken is that the presence of everyone present should be recorded. Normally, what happens is the Panchanamas or the Seizure memos which are drawn, they would only say the officer leading the investigation and the panchas. We do not know. I mean, there are 10 more people present there. So those 10 persons, their presence also must be recorded in there. After all, they are the parts of that search. Then one more problem arises with the recovery of documents. They'll say one dump of documents was taken, or file titled this was taken, red file was taken, blue file was taken. It should not be like this. Every page has to be numbered. the files have to be numbered, signed by the concerned people, by the searched person, and then say that such and such person has numbered the file from page number 1 to 2000, and that file has been seized. Similarly, suppose something very unconnected is being taken away, then an objection should be recorded there and then, that this computer has nothing regarding the case. It is, for example, we saw in one of the cases, you will remember, Shivan, that the iPad of the granddaughter, who was a school kid, was taken. You know, such
Yes.
kind of things happen. So the person concerned must put his objection on record, that this particular document or this particular material which is being seized is not connected with in any way with me. It belongs to a child, it belongs to his wife, it belongs to someone else. It could be in trust with him. You know, he may have some property which is in trust with from somebody. So he has to record that. Then there is a practice of bringing the panchas with the search team. You know, they will bring a punch who belongs to 200 kilometers away from that place, or at least he does not belong to the locality. So an objection should be raised there and then, that these people cannot be the panchas. The panchas have to be random people. They are not supposed to be the people either under the influence of the searched person or under the influence of the department. Now, Ashwini was talking about offering for search. Now, to my mind, just offering for search is not enough. It should be searched. The team, the officers must say that please search us. They should not say that you want to search us. I mean, can anybody say, yes, sir, I want to search you? But it's something he will say in an intimidating voice or intimidating tone that करनी है, हमारी सर्च करनी है या हम करें? नहीं साहब, आप ही करो. So this kind of situation has to be handled very, very carefully, right? And it is good for the department's officers also to be fair. In fact, they should themselves say that. Otherwise, there can be an allegation tomorrow, sir, इन्होंने तो ऐसे बोला था, intimidating voice में बोला था, हम कैसे search कर लेते हैं इनकी? And why shouldn't we make that allegation if he does that? Why? And as Ashwini sir said that he is carrying backpacks. The team is carrying backpacks into a search, and not one person. Many of the officers are carrying the backpacks. And it's a jeweler's shop where you just need a pudiya, which will be worth 5 crores. So if you want to really plant, or if you want to really take away something from there, if you want to rob that jeweler, then both the things are possible. So these are the cares people have to take a little proactive role. It should not be taken lying down. If search is being offered, search should be done. If the backpacks are being carried, the person searched must say that, sir, please keep it outside. Because you are certainly not going to, by being very nice to the officers, you are not going to earn any goodwill from them. But by stressing upon your rights, if the panchas have come with their team, you should ask, who are these panchas? From where have they come? How are they present here? Or you must put your objection to that when the panchnama is being drawn, that these panchas had come with the team itself. Yeah, you can go ahead. Thank you. Thank you.
Thank you, sir. So my next question is whether the search person is entitled to a copy of search warrant and the Panchanama.
Because search warrant, I just told you that according to
I
me,
think,
the
yeah,
fairness
please
demand
carry
that
on.
the warrant should be served, but it is not neither in practice nor any clear position of law. But it should be copy should be provided. Now, service of Panchanama is mandatory as per law as well as principles of natural justice also. Because Panchanama will only detail what are the things which are being seized, impounded, taken away, and recording of all the events. So, service of Panchanama is important. Ji.
We have a question related to it. If you want to like it, answer it. It is from Paresh Vasant. Is a search person has the courage to check the team?
That is what Khemkaji said very rightly. That there are certain things which will happen only when the department is willing them to happen. For example, presence of a lawyer, recording of statement in a fair manner, carrying out search in the fair manner, not in intimidating manner. So these are the things where the everybody, I mean, is a helpless citizen at receiving end.
No, I will put it like this, that they should have the courage, because it is not going to pay them not to have that courage. You know, they should be gentle with them, right? That is another thing. They should not misbehave with the officers. But sir, they should say, sir, it is but fair that I should search you, sir. There is no harm in it. Okay.
Rather, it will give a clear signal to begin with itself that the officers will keep in mind that the procedure and fairness has to be followed. Otherwise, there will be a lot of obstacles on the way.
So I feel that courage is not going to be counterproductive actually. If you are gentle with them, you should offer them a cup of tea. You should offer them a proper place to sit. You should offer them every other facility which is required. You should be cooperative with them, right? Then, should law make search should be video recorded? You know, we are on that process. The Supreme Court has already said that, look, the statements being recorded by the different agencies must be video recorded. So I feel that we are certainly taking steps in that direction, and the day is not very far off when the search also should be video recorded. And why not? Search should be video recorded for everybody. You know, look, if there is a criminal, if there is a wrongdoer who is on the wrong side of the law, now this kind of a search where it has been video recorded and something incriminating has been found with him, you have nailed it. And at the same time, people who are innocent and who are being framed, they will not be able to frame them. So it only will result into more fairness. It will all more result into better administration of law. So I feel that why shouldn't there be a law for that? Thank you.
Thank you, sir. Sir, my next question is, what are the rights of investigating agencies or SIR team with respect to recording the statement under these laws, as you have said? And is there any corresponding responsibility of the investigating agencies or SIR teams?
Yes, Ashwini, please start and then I'll add.
Well, recording of statement is a very, very important power, very significant power, which has been granted to the officers, whether during the course of search or without any search, post-investigation or in simpliciter investigation, from various angles. Because it is from the angle that the officers are allowed to exercise their requisite skill in extracting the truth. So that is, one part of the situation. The other important aspect is that this, with the help of statement, in fact, it is a opportunity of stating the things correctly to the person whose statement is being recorded. So in fact, the law aims to fulfill both the purposes simultaneously. What is happening, unfortunately, is the department officers are thinking only one aspect of the matter, that it is only a measure which is allowing them to use their skill to extract the truth, or the truth in the manner they want to extract it. So other important aspect, that it is in fact a kind of opportunity to the person to come clean and state fairly whatever he knows about the things. So that is where the things have gone haywire. But if officer, whatever powers, if you are talking about, is he has power to administer oath wherever the statement can be recorded on oath. He can tell the person that in case the statement is not recorded, if the statement is truth is not stated, then he can be liable for perjury. Then he can ask the person to sit and to give the statement unhindered, without being interrupted. He can confine him to that extent. Of course, not in an intimidating manner, or not in a manner that he should feel that some kind of force is being applied upon him. That is not permitted under the law with respect to these investigation agencies at all. So, these are the few rights which, yes, Khemkaji, now you can add whatever you want to say.
Yes. See, Shivan, there is actually, I would say that there is nothing called rights of an officer. Like you asked the question that what are the rights of the officers? Officers only have duties. They are only performing a duty to investigate in order to unearth the truth about a suspected wrong. That is what is their duty. They have certain powers in the process of that duty. And those are the powers to administer oath, to summon a person, to ask questions, to ask him to deliver documents, to ask him to deliver property, to ask him to deliver the truth. Now, they are not the rights of the officer. I call them, I would say that they are also the duties of the officers. And how the duty is to be performed? Fairly, objectively. Like Ashwini sir said, that if you start performing that duty with a preconceived notion, if you have already decided that I feel that this man is a culprit, and then I just have to somehow collect evidence to frame him, then you are not performing your duty. So the question is that this officer, when he is performing this duty, and the law says that this performance of duty is judicial proceeding. He is recording this statement on oath during investigation. When the police records a statement of a person, and in CRPC, the police is barred from recording a statement on oath. The statement given to the police is not admissible in evidence. Here is an officer who has been given the power to record the statement on oath right at the word go. When that kind of power is with him, which power is only available to a judge under the law, he has to be responsible about it. That power has to be responsibly exercised. And that power cannot be utilized to achieve a desired result. It has to be utilized to achieve, to unearth the truth. And there is no doubt that these people are very smart people who commit these kind of offenses. They are unlike the normal criminal. They have not committed those offenses out of some kind of an impulse. They know what they are doing. They have planned it for till eternity. And that is why the law gives such powers to these officers while investigating, which are not available to the police. But question is that by not exercising the powers in the desired manner, or in a justifiable manner, or in a fair manner, or in an appropriate manner, they might actually be doing something which is counterproductive. And they might actually be making the value of these statements given as nullity. Because when such powers are given to such officers, the courts also are skeptical about the exercise of those powers. They know that there is a scope of misuse. They know that there is a scope of coercion. There is a scope of force, intimidation. So the courts are also skeptical when these powers are being exercised in an inappropriate manner. Thank you.
Thank you, sir. Sir, my next question is, what are the duties of the searched or summoned person whose statement is being recorded?
See, the first and foremost duty is to believe in the majesty of law, according to me. Okay. We should not consider the officer as our enemy to begin with. Unless the officer starts doing something which is illegal or unfair. The first and the foremost thing is that once a person is summoned, once a person is called upon to provide information, he should cooperate. He should state the truth. He should not try to circumvent the issues or circumvent the law. It is the basic and the primary duty, and the duty to be courteous, duty to be respectful to the officer. After all, he is only performing a public duty. So we cannot, and it will also help the person concerned, because if he starts doing things right at the very beginning by considering the officer as his enemy or as adversarial, he will not be able to give his best. If he treats him as a friend, if he treats him as a person who is responsible to perform certain public duties, and the person concerned also must go ahead. If he is not the culprit, if he has not done anything wrong, he should not be afraid. Why should he be afraid? So I feel that it is the duty to cooperate, and that is a very broad word. It involves that whatever is, they should be, the person concerned must believe in the majesty of law. However, there are certain rights which this person has. Okay. And that person should not, as we said, that if there is an opportunity or occasion to search the witnesses or search the officers concerned, why should they not be searched? But it should be as a matter of routine. It should not be made an issue of. If there is a requirement, if you feel that there is some legal issue on which you require the legal advice, you must say this. If a person will not say, if some legal provision is being told to him, which he doesn't know, he should say that, sir, either allow me to consult my lawyer or to talk to my lawyer, or I cannot say anything about it. So there should be, things should be done matter of factly. If a person is sick, he must stress that I need medical advice. If it is time for your lunch, you must say that I need lunch. I need tea, I need coffee, and you must stress those are your rights. You have the right to know the identity of the witness. You have the right to know the identity of the officers. So all those things should be done in a matter of fact manner rather than making an issue out of it. And mind it, all these things will not impact provided you are cooperative, provided you are also performing your duty of cooperating with the agencies, that which is very, very must. There's a question here. No, it's not very clear. Rajendraji's question is not very clear, actually. Anyway, Shivan, you can continue.
Yes, sure. So my next question is, what is the admissibility of the statements recorded under these laws under different situations?
Yes. See, the law on this topic has been evolving for almost 4 decades, 4 or 5 decades rather, if I may say, 5, 6 decades. The law says that a statement made to an officer who is not a police officer is admissible in evidence, while the statement made to a police officer is not admissible in evidence. And to add to it, in these economic laws, the process of collection of evidence or the process of recording of a statement is considered as judicial proceeding. The power is given to the officer to record a statement on oath. So these statements are certainly admissible in evidence. That is what are the pronouncements of law. Even when the said statement is self-incriminating. But the question arises that whether a statement given to such officers or in such proceedings or under these laws, whether under section 50 or 132 or 131, whatever, whether these statements on a standalone basis or without any corroboration can become the basis for conviction or for adverse finding against a person. As I said, that the law has been continuously developing. And also we have to appreciate that there is a difference in admissibility of the statement and the evidentiary value of a statement. A statement under these laws is admissible in evidence, no doubt. But that doesn't mean that such a statement is per se enough for the purpose of arriving at conclusions. That cannot be the sole basis for arriving at a finding. The law says that if there is any doubt about the fairness of the said statement, or if there is any doubt about the statement not being voluntary, or the statement having been extracted by intimidation or coercion or pressure, such a statement will require corroboration, and its authenticity and the onus to prove that this statement was taken in an atmosphere which was devoid of any pressure or coercion or intimidation will squarely shift upon the agency who is seeking to rely upon it. What I want to say is that while the statement may be admissible in evidence, it will still require something more for it to become the basis of conviction or basis of arriving at a finding. Especially if it is a retracted statement, especially if any doubt can be created upon that statement. The law actually says that even if no doubt is created, even if no challenge is made to the statement, still there is a duty upon the department to prove that the statement was obtained fairly. Now let us take an example that a statement was taken fairly, statement was obtained on oath. And the statement says that Taj Mahal was sold by me to Shivan Kukreja. Right? Now, will the court believe it? Can that become the basis of the finding of the court? No. So, if there are certain verifiable facts which were not verified, or if there was possibility of a corroborative evidence available which was not obtained, or which there are certain judicially noticeable facts which create doubt over that statement, in such situations, that statement will lose its evidentiary value. So just because a statement is admissible in evidence, it does not mean that it has 100% evidentiary value. It will depend upon the facts and circumstances of each case. It will depend upon the attending circumstances as to what kind of value the court or the adjudicating authority puts on such a statement or puts on such information. Ashwini ji, you want to add something to it?
I would say the statement could be a very good piece of evidence, but not something invincible, not something unassailable. Just pardon me for this. Not something unassailable. It is not something that it is, you can say it is like a bullet which has to be used properly. This is not a gun in itself. Meaning thereby, there are 10 number of things to make a statement of an adequate evidentiary value. Admissibility may be there because of the force of law, but the evidentiary value is not impeccable. It will vary case to case, circumstances to circumstance, situation to situation, and I mean, it is shaken up very fast. What I am trying to say, that suppose a statement is retracted, what will happen to that kind of statement? Whether still it will be blindly applicable? Suppose it is shown by the person whose statement is reported to show that whatever has been said is contrary to the records admitted or available on record, to the entries, just contrary to what? Or if it is shown that it was said something on the basis of memory, then all these things, pardon me, just 1 second. All those things will definitely come as an obstacle, as a stumbling block in the way of the investigation agency to enforce upon and make blind use of such kind of statement. So the kind of practice and impression which has been gathered by the investigation agencies, that the statement has been recorded, that is the end of the matter. No, it is not good. If this kind of practice is allowed, then I mean, no investigation is required. Just give 2 tight slaps to a person. He will state whatever is required to be stated. So that is why our judiciary has been wise enough in this, that they do give admissibility value to the statement, but not the complete evidentiary value to it, for various reasons, which some of which we can mention on this forum, some we still cannot. I mean, those who are actively practicing in under income tax law or even GST. So CBDT has given circulars right way back from 1955 and subsequently also, that no, you cannot take concessions, admissions, surrender by way of statements. No, this is not a healthy practice. So statement is an effective tool, but not a Brahmastra. It has to be used sparingly, fairly, properly. And so is to be noted by the persons whose statement is being recorded, that there are certain principles which are to be kept in mind while recording the statement. And those principles, if not kept in mind, sometimes something which is not the truth or something which is not required to be stated is stated, and based upon the guesswork, because of the stress, trauma, tension, whatever you may say. So statements expects you to state something which is humanly possible to be stated. You cannot recapitulate the data. So statement is not like exam. It's not test of your memory. Like in the examination paper, we appear and we try to attempt the questions to the best of our guesswork, memory, intelligence. No, statement is something which you at any given point of time is supposed to know, and you know it and you state it as it is. That is what the statement is. Nothing beyond than that. So commenting upon by third person, anything else which is not related to you, neither you are supposed to do that, not you should do that. So mistakes are happening on both the sides, in fact. And the investigation agencies are happier in committing you people to make mistake, the person whose statement is going to commit mistake, because their mistakes, they are sure will be ignored because of the bad weather going on. And the mistakes done by you will definitely be used against you. So this recording of statement has become a very, very unethical, unfair, unwanted exercise in the entire country by various investigation agencies. I need not speak much on that. So everything is hinging upon the statement. Okay, by harsh actions are proposed. What is the basis? कि सर हमने उनका statement लिया और उन्होंने ऐसा कह दिया. So is this can be a process of law, and that too statements are recorded, dehorse any camera proceedings, dehorse presence of lawyers, dehorse opportunity of cross examination. I mean, what kind of statement that statement would be? Under stress, you will be ready to state whatever is other person is willing to have recorded. Thank you.
Thank you so much, sir. So my next question is whether a statement recorded by investigation agency say X be used by the investigation agency say Y, and if yes, what would be the admissibility or evidentiary value in such a scenario in the proceedings carried out by the investigation agency Y?
Very, very important issue you have marked, Shivan. In fact, this is another area where mistakes are happening. And I do not know why, the agencies are so over enthusiastic, or they do not want to do hard work, or what are the reasons that such kind of things are happening. That tail I win, head you lose. This kind of approach is being followed in many cases. Now, I will try to explain with the help of some examples. Now, under income tax proceedings, some searches had taken place way back 10 years. Some actions were done, some additions were made under Section 68, etc. Whatever happened in those proceedings is one thing. Now, since after introduction of Benami law, under proceedings being carried out under Section 19 and 24 of PBPT Act, the BPU is making use of that statement. Right? For 10 years back, so and so person had stated that this is so and so bogus entry. So therefore, because of that, the present share capital or the property held by this company who had received that share capital 10 years back by the previous management, when the previous management was there. So that makes this transaction as Benami, and this property which is held today or owned today also makes it Benami. Now, 3-4 mistakes on law and facts have been committed here. First of all, the law under Benami is totally different, and the law under income tax is totally different. The fabric itself is different. Enforcement agencies may be common because of the deputation and user of the infrastructure, but law is totally different. Different laws, different fabric, different game of burden. Everything is different. The basic jurisprudence itself is different. But you are making use of that statement. That is the first mistake. I'm not saying you don't have right to make use of that statement. But that statement gives only the power to you to make initiation of the inquiry, not to draw conclusions on the basis of that statement, which was taken 10 years back in different contexts under different proceedings. You can make use of that, but only make use of that, not to draw conclusions, to initiate inquiry. Then the duty upon you was to make inquiry, and based upon that, reach your conclusions independently, fairly. What will be needed for that? You will confront that statement. You will call that person whose statement was recorded, put him before us for cross-examination to the present person against whom this is being used, and also record statement of the present person whose action against whom is being taken. So these 3-4 things have to be done. Now, what is happening? That statement is being used. All right, on the ground that we because these are same agencies, so therefore can be used. All right. Then somebody replied, sir, in the proceedings where this statement has been used, it has been branded as nullity in the eyes of law because cross-examination was not given, and no additions have been made under Section 68, and that share capital has been treated as genuine. So here also you leave. Now the stand of the officer will be, no, I am an independent agency. Maybe under income tax proceedings they have left it. I can make use of it. All right. But you remain on one side of the philosophy. Either income tax proceedings are same, then you adopt whatever has happened there here also. If you say, no, these are not same, these are different, then you do not make use of them to draw conclusions. You carry out your proceedings independently. So it is not possible that head I win, tail you lose. No, you decide what? One thing. Either these are different proceedings or these are same. If these are same, everything has to be done here. But let us follow the law. Try to understand the law. The law is these are different proceedings, different law. Any evidence percolating, floating, surfacing anywhere, of course, can be used by an agency. Who stops? But only for the purpose of making inquiry. It is a limited user which is allowed, not to reach onto the conclusions. So that is where the mistakes are happening. Thank you.
See, sir, I'll just add very few things quickly because we are running out of time now. Section 80 of Evidence Act allows the use of the records of another judicial proceeding in a collateral proceeding or in a different proceeding. But what is a record of a judicial proceeding? A statement which was held a nullity, or which was held illegally procured, or which was not properly proved, or which was not subjected to cross-examination. That doesn't become the part of the judicial proceedings. as Ashwini ji rightly said, that a statement which was in those proceedings also was not put to subjected to cross-examination, or the cross-examination was not allowed there also, it will become part of the judicial proceedings only after the cross-examination has taken place. Okay, and where the court has taken the cross-examination and the statement put together will be the part of the judicial proceeding. Now, another thing which I want to add, that if you want to use the statement recorded by X in Y proceedings, in Z proceedings, then not only the X and Y both have to be called here. The person who recorded the statement also has to be put to cross-examination. Unless that is done, these kind of proceedings, these kind of things cannot be done. So what we want to say is that objections, we should start raising objections to such kind of use of proceedings or of the material collected under one law in the proceedings under other law. The objections have to be put right at the word go at the initial stage itself. It may be a little late later on. So one has to say that please allow me the cross-examination of the officer who had recorded this statement. Please allow me the cross-examination of the person whose statement you seek to rely upon against me. So all those things have to be done at the word go. If you have to challenge the illegality or if you have to challenge the authenticity, it has to be done at the earliest possible opportunity. I think we have run out of the time, and Ashwini ji will like to conclude.
Yeah, for example, I will read subsection 4. The authorized officer, 132.4 I am reading. Authorized officer may, during the course of search or seizure, examine on oath any person who is found to be in possession of control of any books of account, document, money, etc., and any statement made by such person during the such examination may thereafter be used in evidence in any proceeding under the Income Tax Act. So what is the law is clearly saying? Can be used in evidence. So deeming value is there, but deeming value is confined consciously by the legislature, expressly by the legislature for the purpose of this act. So we can take indication from these kind of provisions. So where even when they are deeming the value, they are deeming it as evidentiary value, they are saying, but we are confining it to the proceeding under this act. Yes, please go ahead. Sir, I think now you can conclude.
In the case of KTMS Muhammad, Supreme Court actually said that those statements were made in a totally different context.
Yes.
You know, a person might have made a statement in context of something else. You want to use it in some other context.
Yes.
So why shouldn't you do your own investigation?
Yes. Sir, I think now we can take up one important issue which is left out, which is the concern for everyone. And I can see some questions also coming there, is with respect to retraction, sir. So let me put forth the question on behalf of Shivan to you. So what kind of retraction? First of all, my first question, which is coming to my mind, let us both will answer that, which is coming to my mind is, if a statement is not retracted, what is the evidentiary value of that? If it is retracted, what is the evidentiary value of that? A. B, even if the retraction is to be filed, what are the basic parameters which will decide its authenticity and to whom it should be filed and in what time limit it should be filed, sir? If you can begin with it, then whatever little I know about it, I will give my additions to it, sir. And then we will conclude this session.
So far as the statements which have not been retracted, we have already answered, I suppose, that it is not 100% or the statement on a standalone basis, its evidentiary value will depend on the attending circumstances that we have already answered in detail. Now coming to a statement which has been retracted. Now retraction per se does not make the statement unreliable or inadmissible in evidence. The statement still remains admissible in evidence. in spite of there being a retraction. Again, the question is, the retraction can only hit on the evidentiary value of the statement. In order a statement or a retraction is effective or it has the desired impact, it should be reliable. The attending circumstances and the language and the retraction per se must have the result of convincing the judicial authority that it was a genuine retraction. For example, the retraction has to be made at the first given opportunity, first available opportunity. The first available opportunity may come after 1 month, but it has to be done at the first available opportunity or at an opportunity wherever. But that doesn't mean that suppose it was not made at the first available opportunity, it should never be made thereafter. Even later on, even if a retraction is delayed, that per se may not make it unreliable. What will make to my mind, what will make a retraction reliable is its contents. There can be a stereotyped retraction that, sir, I went there, my statement was taken under due pressure and coercion, and that was not my statement. A judicial authority might just seek to brush it aside as a stereotyped mechanical assertion. But on the other hand, if it is said that, sir, I went there, there were 3 people surrounding me, all the 3 were asking me questions, they had intimidated me, I was put questions which I could not understand, still there was a bombardment of questions over me. Though you are saying that you never, they did not even touch you, but you are clearly communicating that the circumstances were such where your statement was not free, fair, and just. So it is necessary that a retraction should be such which inspires confidence. And once a retraction is such which creates a doubt over the statement, then in that case, the onus of proving that the said statement was taken or was recorded by following fair and just circumstances shifts on the authority itself. And as we said, that all other circumstances will also be taken into consideration while seeking to evaluate a retraction. Ashwini ji.
I would say something like this, as far as the timing is concerned. Like you pour water in a heap of cement. So the longer time it is, it becomes rock. So if once statement is given, like you have poured water into cement and it is becoming like a rock. So as late as you are getting, you will not be able to break that rock now. But this principle is subject to some exceptions. Suppose a statement was taken 10 years back in some different context, and today it is being used in some different context. Then today also I can have the opportunity of retraction. Again, this privilege will be again subject to some exceptions. So this is with regard to timing. So sooner the better. Rather, Khemka sir himself was saying something that suppose your statement has been done illegally. Somebody was mentioning that some statement was taken of husband and wife, and forcibly some things were taken. Immediately coming out of the clutches of that officer who has done things wrongly with you, immediately thereafter, maybe within few hours, shoot back the retraction through post, speed post, mail, whatever is possible, and narrating the facts in a truthful manner. The retraction has to be as large as possible, but not making it vague. As large means so that it could bring out all the attendant circumstances. What are the total things, how it happened? That any reader of that statement can portray a picture before him that what had happened exactly. For example, in one case, what happened? I said to the gentleman, "You are such a wise person. I mean, why did you state like this?" He said, "Sir, what did I do? I am a person belonging to a very civilized society, very civilized family." The gentleman asked me, that officer asked me to sit down on the floor, and he took away my glasses and he took away my coat and he touched me from behind on my back like this. So I cannot say he punched me, he hit me, but the way he was touching me, I mean, I was feeling embarrassed. So these 4 things you have to mention. That's it. And he said that I will let you go only when you record the statement. And then he typed the statement and he said, "You read it and reproduce it in your own handwriting." So I had to reproduce so that I could go back. I was feeling so embarrassed. I could not have tolerated more. I am a heart patient. I would have died. So, etc., etc. Whatever has happened, just narrate the truth so that the reader of the retracted statement will be able to know with his eyes, that what had exactly happened. That's it. Last thing, to whom it should be addressed. Now, there are different ways and means to say the whom should be addressed. I mean, one way is that it should be addressed whosoever has recorded the statement. But one day I was discussing with Khemka sir. Khemka sir was saying, what is the purpose of sending it to him? Because he is not going to help you. So you send it to his senior. So I will reconcile both the thoughts like this, that in case you are expecting any relief from him, that okay, some relief should come now, something should be stopped. So then you have to approach his senior. Sir, this has happened. Can you stop him? But if you are doing it as a part of legal obligation so that higher authorities later on can be told that it was not a valid statement, I have retracted it, then I think you can send it to him only. Or other way can be you send to him, mark a CC to all the seniors. If you have that much courage, which is the ideal state of affairs. So that is what I would like to say about retraction. I would say that those who have made any statement under some compulsion, pressure, threat must retract it, because sometimes it looks very sweet that we have made surrender and now we will pay this much of tax, but maybe by payment of small tax, you may be coming out of the ditches of the income tax law, but where else it is taking you and in the dark gullies, you will not be able to imagine. So that was our next issue probably, which I am touching upon quickly, that any surrender, any confession, any admission, if it is to be made, kindly beware of this fact. Now the only implication is not income tax or GST. Implications are far more. PMLA, Benami, black money, whatnot is staring out your head. Plus various things we cannot even calculate. So therefore, keeping in mind that, you have to approach settlement. Now settlement in any case has been dismantled. So whatever you are going to do with regard to admissions, you have to think twice before you do on that aspect. Thank you very much, my dear friends.
Thank you, Ashwini ji. Amit ji, anything you want to add on this?
No, thank you, sir. We have already traversed on the time of Shailesh Bhai.
Yeah.
So we will not take any more time. And
one question is there from our co-chairman, Mr. Ashok Mehta. Ashok Bhai, you can ask the question. Ashok Bhai.
Yeah, sir, there is a new practice that the officers have started beating up the accountant, and they don't do it themselves. Sometimes they do it themselves, but they use the Havaldar or the police personnel who are accompanying them to beat up the accountant before the this.
अशोक भाई, आपको क्या लगता है पुलिस को क्यों लेके जाती है टीम, जो आइडियली वाई लॉ प्रोवाइड्स?
To protect them, protect the officers.
No, that is where we are mistaken. The police force is being provided to ensure that nothing unfair or illegal happens on either side. The team should be protected. The team should also not do something wrong. कि कहीं कुछ प्लांट कर दिया कागज, कहीं किसी को थप्पड़ मारा. That is the role of the police. That the police has forgotten its role. Rakshak has become bhakshak. What would you do?
No, you can actually call 100 number.
Yes. Immediately call 100 number. कि सर ये पुलिस वाला भी अपनी ड्यूटी नहीं कर रहा है.
And that police wala will record your complaint, who is accompanying the team.
Yes.
If you say that I am calling 100 number, he will record your complaint for sure. He will say, no, don't call 100 number. Tell me what is your complaint. I will record and I will give you the receipt.
Okay.
That's the
Okay.
point. Yeah, yeah.
That's fine.
Of course, these kind of practices are happening because that is your accountant is the weakest link possible. Okay. And these accountants have in some cases we have seen they have a habit of maintaining their parallel books. So those accountants are actually very vulnerable people. So they are not only doing things which are not even authorized by the party, they are doing certain unauthorized things, and that becomes a tool in the hands of the agencies to force that accountant that we will make this case on you, we will make that case on you. So all that is the part of the game. And
somebody was saying that sometimes you do not pick up the 100 number, then you have to ensure using anybody's help, that anybody on your behalf can make a complaint to 100 number or police station ki sir, he is being harassed by some people, some team who has arrived, kindly go there and illegal things are happening.
Make it just after the search is over.
No, I am saying even during the search, if somehow you can convey this message to anybody,
yes,
let him go and record a formal complaint immediately to the police station. Sir, you kindly come to our rescue. Beating is happening over there. Something untoward will happen. Somebody will die. Then
I think we have not allowed Ashok Bhai to complete his question.
Yeah. So can an FIR be filed for beating up the assessee or his accountant?
Why not?
It must be filed.
It should be filed.
It should be.
It should be filed, sir. And if there is any injury, even if there is a slight injury, then a medical should also be got done.
Okay.
The trauma caused would be much more than the physical injury.
Suppose there is even जिसे कहते हैं कि even there are slap was there and there are imprints of a slap, then immediately before they vanish, the person should go and get a medical done.
Right.
He should take the photographs of it.
Right. Okay. Thank you, sir. Thank you. Yeah.
Really, it was a very good learning session. Exactly what our president has said earlier. And really, it will be very useful to us for our professional endeavors. And now I request our convener Radha Halbe to propose a well-deserved vote of thanks to our learned speakers.
Thank you very much, Dinesh sir. It is definitely a wonderful opportunity for me today. Firstly, I have assisted my seniors while arguing before Taneja sir, and now listening to you on this platform on various different issues. It was definitely a wonderful and a learning session. It was a perfect start to our weekend and a lot of food for our thought for the weekend for us to deliberate upon. First of all, I would like to say that both of you have really powerful CVs. That itself was one factor that intrigued us to your session a lot. And the panel discussion format especially was so interesting, and it got out issues that we couldn't even imagine that could happen in a search. I am definitely sure because of your vast experience that we have got to know what things can actually happen that were not even imagined by us before. You told us the do's and don'ts in a search proceeding, and your experience has definitely taught us a lot. As Khemka sir rightly pointed out, it was a learning session, but for us, much more than that, what it was for you. Thank you very much, sir. The interplay between various laws, all of these things were never imagined by us because all of these things are very new for us. And thank you very much from the bottom of our hearts and today. Thank you very much, sir, for spending your valuable time with us today. Thank you.
Thanks to all of you also.
Thank you. Thank you. Now over to Atul Bhai. Atul Bhai.
Yes, thank you. Thank you, Dinesh Bhai. Thank you, Taneja sir. Thank you.
We have the liberty to withdraw, sir.
Yeah, surely, sir. If you,
Thank
yeah.
you. Thank you.
Yes,
Thank
yes.
you very much, sir. Thank
Thank
you. Thank you very much.
So after
Thank you, sir. Thank you, both of you.
Thank you, Ketan Bhai. Thanks to all of you.
Thanks, sir.
Thank you very much.
after an interesting session by Khemka sir and Taneja sir, this is now turn of GST. So we welcome you, Sailesh Bhai, to this gathering. So topic allotted to Sailesh Bhai is summons, search and seizure under the GST law. Sir, we are thankful to you for accepting our invitation, and today you are here to actually address our participants. Thanks a lot for saying. Let me introduce briefly Sailesh Bhai. Sailesh Bhai, he is advocate. He is practicing in the name of SPS Legal. He is BCom LLB. He has 35 years experience in consulting, advisory and litigation practice in the field of indirect tax laws that includes central excise, service tax, customs, state VAT law, CST and GST. Sailesh Bhai has dealt extensively in the areas of central excise, service tax, customs, GST and VAT across the entire trade industry and industry spectrum,